Hello everyone. In this video, I would like to talk about the common mistakes that employers make when it comes to both AWOL, separating employees based on absence without leave, and the mistakes associated with the known common points discipline system that many employers, especially larger employers, make. And the reason that I combine these two things together is because there is one overriding principle, one overriding wrong idea that employers often has that lead to unfair, wrongful, and illegal discipline and terminations and provide workers with the right to file a claim against these employers. So let's talk about AWOL first of all. So what is AWOL? AWOL stands for absence without leave. Many different employers have all kinds of AWOL policies, but most of the time AWOL issues arise in state, county, and city employment, and under California law, absence without leave is considered 5 consecutive days of being absent from work without approved leave. So the key word here is approved. All too often, employers almost play gotcha by saying, I did not approve your leave, and therefore your AWOL separation was appropriate and legal. And when this policy is applied rigidly without regard for the circumstances of that specific employee's absence, it can lead to all kinds of claims of wrongful termination and especially disability discrimination. Here's a common example. Let's say an employee is unable to come to work because he has a diabetic attack, or he has an asthma attack, or he has a migraine attack that lasts a day or two. He's in a horrible condition. He's in so much pain that he's not even able to call the employer. Then when he comes back to work, or 2-3 days later, he advises his employer why he was away, why he wasn't able to come to work. The employer requests medical documentation to be delivered to them within a day or within 2 days, as soon as possible. And that employee is unable to provide that documentation so quickly because the doctor maybe is not available or for any other reason. And he provides that documentation 4 or 5 days later. And the employer says, too late, we're terminating you. That employer doesn't realize or doesn't know that AWOL policies, even if they are otherwise legal, they cannot override the law. If the law says that the employer has to reasonably accommodate an employee with a disability, that an employer has an obligation to provide certain amount of leave to an employee who has a specific medical condition, no AWOL policy can override it, and the employer must take that into consideration. Many employees in state and county government are routinely illegally terminated because the employer says that they provided their medical documentation too late, or because the employer believes, without consulting with any doctor, that that specific condition for which the employer was absent is not considered a disability, because they don't know that the definition of disability is very broad, and it includes a wide range of physical and psychological problems, including diabetes, asthma, migraines, high blood pressure, especially if it's a chronic condition, as well as anxiety, depression, PTSD, and a whole range of other conditions that affects a person's life and a person's ability to complete typical daily tasks. Excuse me. Many employees lose an administrative hearing on AWOL claims. They lose a Skelly hearing because the Skelly officer determines that the AWOL was appropriate. That still does not mean that the termination or the discipline was legal under ADA, Americans with Disabilities Act, or under FEHA, under Fair Employment and Housing Act. So just because you were AWOL separated, and just because the Skelly officer determined that your separation was appropriate and properly done, you should still run your termination by a good employment lawyer to see whether a disability discrimination claim can be made. Often employees who have been terminated, who have been AWOL, they come with a clear paperwork that shows, look, I've been diagnosed with this condition. I've been providing all the medical documentation to my employer with my initial leave request, with my extension of prior leave request. I was 1 day late. I was 1 hour late to give them the documentation that they requested at one particular point, and they did not want to wait for 1 day, for 2 days, and they terminated me. Even they knew exactly what was going on with me based on my prior history, and they still terminated me. That's a typical situation. That's a typical scenario for a wrongful termination and a legitimate claim of disability discrimination. Now, what is a point system? Any worker that has been working in a large manufacturing plant or in other large companies knows that many employers have this system where as soon as you accumulate 3 points or 5 points in a 6-month period or in a year because of your tardiness or because of some type of violation, whether it's policy violation or insufficient performance, as soon as you accumulate that amount of points in that period, the employer can terminate you. And the problem with this point system is often the same as with AWOL. Employers apply this system rigidly without regard to the circumstances as to why the employee was not performing his job as good as he should have or why he was absent. Here are a few examples. Here are 2 common examples. One is very similar to AWOL. One employee has an asthma attack or a diabetes attack. He brings a note from his doctor explaining why he was late on that particular day to work. And yet the employer still penalizes him by putting a point for that absence. And then they count that point toward the entire disciplinary record, and they end up terminating that employee. Even if 1 or 2 points out of the whole amount of points that led to discipline or termination were for a protected leave or because of the protected disability, that employee most likely has a claim for disability discrimination or FMLA violation and wrongful termination that are at least worth looking into. And the common issue with point system and performance deficiencies is this. Let's say you have an employee who has a serious back injury, or he has a carpal tunnel, and he's unable to meet the requirements to keep up with the pace of the work. He provides his reasonable accommodation paperwork to the employer that states that he is unable to type or to stand for longer than 2 hours without breaks, or he's unable to lift more than 20 pounds, or whatever other restriction. And then the employer, without regard to these restrictions, seeing that the employee cannot keep up with the pace, penalizes the employee by giving him a point of discipline for not keeping up with the demands, with the requirements of the job, and eventually that employee is terminated in part because of that 1 point. And then, again, that employee may have a legitimate claim for disability discrimination and wrongful termination because he was disciplined for something that was protected by law. He was disciplined because he had a condition that limited his ability to perform his job 100%. Of course, every situation is different, every case is different, but very often this rigid application of points system in AWOL leads employers to violations of law and to wrongful termination. Thank you for watching. I hope you find this information useful, and I will make more useful videos on employment and injury law in the nearest future. If you have any questions, please email me at arkady@arkadiylaw.com. The email address is in the description, and I will talk to you soon. Bye-bye.